Hey, it's Josh Boorman here outside Newcastle, local courthouse. That's the large courthouse behind me. I've just appeared today on a Middl range drink driving offence. The blood alcohol reading was 0.119, so definitely at the higher end of the Middl range category, given the Middl range category in New South Wales is between 0.080 through to 0.150. Our client was originally from India. He's been here since 2018. In relation to the actual offence, on the day of the offence, unfortunately his relationship had come to an end. His girlfriend had broken up with him. He went to work that afternoon. He works at an Indian restaurant, and he was distraught. He was in quite an emotional state. One of his friends, colleagues at work, suggested that he have some drinks to calm himself down. So throughout his shift, he had about 4 or 5 VB drinks. The last being probably about an hour and a half before he finished his shift, and then made that very poor decision to get in the car and drive home. He was obviously quite emotionally vulnerable, and that's what led him to actually drink in the first place, because he tells me he rarely ever drinks, and then obviously make the poor decision to get in the car and drive home. He certainly, and I quote the magistrate, did himself no favours on the way home by allegedly speeding above the assigned 60-kilometre speed limit. That gave police cause to actually start following him in the first place. And then he actually pulled up to an intersection where he proceeded through a red turning signal, so a red light. So these matters did slightly aggravate the matter. But it was later at night, minimal traffic around, no pedestrians, and he cooperated with police. He entered an early plea of guilty, went and did the traffic offenders program, got some good references. He has only been licensed in Australia for about 3 years. He has nothing on his record, which is good, but as the magistrate said, it wasn't a lengthy period of driving with nothing there. So because of the short period on a license, it is kind of to be expected that it is to be unblemished, but certainly having a completely clean traffic and criminal record assisted him today. He put forward a letter of apology to the court outlining the lessons he'd learnt from the traffic program, concerns about being off the road for too long a period, and obviously his just general remorse and regret over the entire matter. I think my client, there was obviously some mitigating or extenuating circumstances as to why he made the poor decision and failed to use his better judgment on this occasion, and that was his emotional state. It's not every day that a long-term partner actually ends a relationship, and so he was quite emotionally vulnerable on the day of the offence, and that's what led to this offence occurring. So we were, with the levels of aggravation and the reading at 0.119, we were seeking that the court reduce the disqualification period to the minimum period, which is 3 months, for a first offence of mid-range drink driving, and also have the disqualification period backdated to the day of the offence, which was the 7th of December 2023. So being the middle of January, he's already served half the period of time off the road, and he's very well aware that he's got to commit to the alcohol interlock program. The magistrate agreed with us. She was willing to reduce the period of disqualification and fine down to the minimum 3 months. It was backdated, and he was given an $800 fine. So a very relieved client today. He's very concerned how a conviction on his record, criminal conviction, will affect his ability to obtain permanent residency in Australia. I'm certainly no immigration expert, but from my knowledge and experience in dealing with people in similar situations, my understanding is that they actually have to go through a character test, and whilst there's a conviction there on their record, and they might have to provide evidence what the outcome was, My understanding is that it's if they receive a particular lengthy period of imprisonment, that's what can fail the character test automatically. It might be an extra hurdle for my client to go through to provide the immigration department with some evidence just to show what the outcome of today's matter was. But I've had many clients in a similar situation, and it hasn't affected their ability to become a permanent resident in Australia. So I told him that, but I also told him to get proper immigration law advice from a migration agent or a migration lawyer. But he's happy today. He can put this behind him and know where he's going in the future. And yeah, thanks for tuning in here today at the lovely Newcastle local court. I want to thank you for tuning into Boorman Lawyers today. You can catch us at any of the usual social media platforms. Please subscribe to our YouTube channel. And if you've got any questions or queries, please don't hesitate to contact us on 1300 941 900. Hey guys, thanks for tuning into this video today. I really hope it was informative and helpful for you. There's another couple of videos below that you might want to check out that may be very useful for the process that you might be going through at the moment. Please feel free to like, follow, share, and subscribe to our YouTube channel because we've always got fresh new content coming through all the time.